As we move forward from strict statutory compliance and environmental hazards, we now step into real-world application, where agents are required to make judgment calls every day. This section is designed to mirror the types of questions that arise in actual transactions, where the law is not always black and white, and where understanding the difference between material facts and non-material facts becomes critical. This is where knowledge turns into decision-making, and decision-making determines liability. One of the most common areas of confusion involves what must be disclosed versus what is protected under the law. Consider a situation where a listing agent learns that a seller recently recovered from swine flu. At first glance, an agent might assume this is something that should be disclosed for health and safety reasons. However, Arizona law provides clear protection in this area under ARS paragraph 32-2156A. 2, which states that there is no obligation to disclose diseases such as HIV/AIDS or any disease not known to be transmitted through common occupancy of real estate. This statute reflects an important principle. Not all information is material. In the case of swine flu, transmission through surfaces is short-lived, and it is highly unlikely that a buyer would be exposed after closing. Therefore, this type of information is considered non-material and protected from required disclosure. This protects both the seller's privacy and the agent from unnecessary liability. Now contrast that with a situation involving documentation and compliance. When completing the lead-based paint addendum, the question arises, should all listing agents sign the form? The answer is yes. Any agent who expects to receive compensation in the transaction must acknowledge the disclosure. This is not optional. It is part of federal compliance and ties directly back to the duties discussed in the previous section. Failure to properly execute documents is not just a paperwork issue, it is a compliance violation. Let's move into a classic disclosure case that highlights the concept of material fact. A buyer purchases a newly constructed spec home, believing it is equipped for gas appliances. After closing, the buyer discovers that no gas line was installed. The builder argues that the buyer could have discovered this during the inspection period. However, Arizona case law clearly rejects this defense. In Hill v. Jones, 1986, the court established that sellers must disclose material facts not readily observable. The absence of a gas line directly affects the property's value and usability, making it a material fact. Additionally, in Barnes v. Lopez, 1976, the court held that a seller can still be liable for misrepresentation even if the buyer had the opportunity to discover the issue independently. The key takeaway is simple. The duty to disclose is not eliminated by the buyer's opportunity to investigate. Next, consider how these rules apply in REO, real estate-owned transactions. A bank acquires a property through foreclosure and attempts to sell it without providing lead-based paint disclosures. The bank may assume that because it obtained the property through a trustee's deed, it is exempt. However, this is only partially correct. While the foreclosure transfer itself may be exempt, the resale of the property is not. Once the bank acts as a seller, it must comply with all standard disclosure requirements, including federal lead-based paint laws. This reinforces an important concept. Exemptions are transaction-specific, not property-specific. Another common issue arises with inaccuracies in the seller's property disclosure statement, SPDS. If a seller fails to disclose prior termite treatment and the buyer discovers this after the inspection period, the situation becomes legally significant. Under the AAR residential resale contract, the seller has a duty to update disclosures. If the seller fails to correct the SPDS after receiving notice, the buyer may issue a cure period notice and ultimately cancel the contract. This ties directly into AAC R428-1101 and the duty of honesty and disclosure. Even if the omission was unintentional, it does not eliminate the obligation to correct it. Disclosure is an ongoing duty, not a one-time event. Finally, we address a question that often surprises agents. Is the SPDS required by Arizona law? The answer is no. Arizona does not require the use of a formal SPDS by statute. However, common law, supported by cases like Hill v. Jones, requires disclosure of all known material adverse facts. This creates a practical reality in the industry. While the SPDS is not legally required, it is one of the most effective tools for ensuring compliance and protecting all parties. In practice, refusing to provide an SPDS often increases risk rather than reducing it. As we prepare to move into the next section, we will shift from disclosure and legal interpretation into broader issues of fraud, predatory practices, and ethical responsibilities. The scenarios in this section demonstrate that real estate is not just about knowing the law, it is about applying it correctly in real time. And in today's market, that ability is what separates an average agent from a true professional. Online discussion. Why is swine flu not considered a material fact requiring disclosure in a real estate transaction? Answer: because it is not a disease known to be transmitted through common occupancy of real estate, it is protected under ARS, paragraph 32, 2156A2, and does not require disclosure. Why can a seller still be held liable for non-disclosure even if the buyer had an opportunity to investigate? Answer: Arizona case law, including Hill v. Jones and Barnes v. Lopez, establishes that the duty to disclose material facts is independent of the buyer's ability to discover them. Why is the SPDS commonly used even though it is not required by Arizona law? Answer: it provides a structured method for disclosing material facts, reducing liability risk for both the seller and the agent, and helping ensure compliance with disclosure obligations.